Hello, our continuing heat wave has got me back onto the topic of tree root subsidence, and today I'm picking up on the House of Lords case of Delaware Mansions versus Westminster City Council, and the couple of rules that come from that, primarily the opportunity to abate rule. Delaware Mansions is a London mansion block on Delaware Road in Westminster. Along the road are local authority owned plane trees, and back in 1989 Delaware Mansions started to crack as a result of the extraction of moisture underneath the foundations of the property by the local authority trees. As a result of the crack damage, the mansion block was underpinned, which means that the depth of the foundations were taken down beneath the presence of the roots of the trees and allowed the property to stabilize. And the outcome of the decision is that in order to be able to recover the cost of that underpinning work from the liable tree owner, before you do that, you have to show that you have given the tree owner what's called the opportunity to abate the nuisance. What that means is, before going ahead with underpinning works, you need to write to the tree owner, whether that's by letter, as it probably was back in 1989, or now by email, putting the tree owner on notice of the damage, giving them the evidence in support of causation, showing that the tree is the cause of the damage, and inviting them to abate the nuisance, i.e. carry out works to the trees to stop the ongoing effect of the trees to the property, and advising them that unless they do that, and do that to stop the ongoing effect of the trees, then underpinning work will be carried out and a legal claim will follow to recover those underpinning costs. Underpinning tends to be one of the most costly solutions. So in this situation, in this case, there was over £500,000 spent on underpinning Delaware Mansions, and that was the amount that was sought to be recovered from the Westminster City Council in the legal claim. So as well as opportunity to abate, it also spoke about timelines. So in the law of negligence and nuisance, there are 6 years to be able to start a legal claim against a third party to recover damages. Those 6 years tend to start to run from the date the damage was noticed. So in Delaware Mansions, that was back in the summer of 1989. However, what the case said is that the 6-year period for the recovery of the underpinning costs actually starts to run from the date of underpinning. So that extends the limitation period a little bit in respect of those higher value costs. That decision was considered in a later case then of Ellie Jones versus Portsmouth City Council. The council in that case tried to defend the claim by saying that they weren't approached and given that opportunity to abate letter. However, the court said that in order to rely on that as a defence, the council would need to show that had they been given that opportunity to abate letter, they would have used that notice time to actually act in discussions with the claimant and do some work to abate the nuisance. As Portsmouth were unable to show that they would have done that had they received the letter, then they were unable to succeed on that point in their case.